Good evening, everyone. Goeienaand, Moweni. My name is Nicola Smith, and I'm the Dean at the Faculty of Law. And it's my pleasure to welcome you in our centenary to this annual Intellectual Property Public Lecture. I know that we have quite a few people and quite a few distinguished guests in the room and also online following us on the live stream. So I would like to acknowledge your presence and thank you for your support and your participation. I do want to extend a special word of welcome to our deans. I see Professor Leysens, I see Professor van Niekerk. Thank you for supporting our events. And of course to our international visitors who are here tonight. And our very special speaker, who I'll say a little bit more about shortly. The first public lecture of the Anton Mostert Chair in Intellectual Property took place in 2013. But of course the chair itself originated and was established already in 2010. Professor Owen Dean was the first incumbent of the chair, and Professor Sadullah Kajika followed in his footsteps in 2016. So Professor Kajika is also at the moment our acting head of department for mercantile law, and I know, Sadullah, that you have quite a heavy teaching load this semester. So from my side, I would like to thank you and your team for putting together this event tonight and making sure that we can have our first formal event in person again in quite some time. And I think that's something that I almost feel like I want to applaud you for. So welcome, colleagues. It's wonderful to have people here in person at the OWIF-gebou. The Anton Mostert Chair's aims or objectives include to develop and promote intellectual property law. And to that effect, it includes both teaching and research in that field. So it's by design that you will find that IP law is offered in this faculty at both undergraduate and postgraduate level. And in fact, we have an IP short course, an LLM, a master's course, as well as a postgraduate course in IP law that's offered. So a wonderful array and articulation options. And very soon we will also be offering a service course to our science faculty, about which we are very excited. Our special guest tonight that I just want firstly to welcome, and then Professor Kajika will probably introduce Professor Thomas Hoeren, is one of our guests that's traveled all the way from Germany to Stellenbosch, and we're so thankful for that. Thank you for joining us tonight, giving us this opportunity to listen to your address. I think that everybody in the audience will agree with me that the topic of IP law in the information society is really a very relevant and exciting topic as well. I think I've spoken to a few people who's in the audience, and I'm certain that if there is an opportunity for some interaction and comments and questions afterwards, it will be fantastic. Thank you so much. I know it's quite a short visit that you have, but I am confident that we will welcome you back in Stellenbosch at some point in time. So on that note, very much warm and hearty welcome to all of you. I'm going to hand over to Professor Kajika. Sadullah, am I correct? You're next up. And then we'll take it from there.
Thanks, Nicola. Good evening, ladies and gentlemen. It's a great pleasure to welcome you to the 2021 annual IP lecture hosted by the Anton Mostert Chair of Intellectual Property Law. As you saw, I stumbled on the date because we missed one last year, due obviously to the COVID pandemic. So we're delighted to have people back and to present the lecture again. We're joined by, of course, our Dean, our Vice Dean, and Deans from some of our other faculties. Unfortunately, due to the COVID regulations, we could not accommodate all those who wanted to attend in person, and therefore we are live streaming this event. We will also be making a video of this lecture available in about a week or two's time. So don't worry if There are connectivity problems for those who are logging in online. I know the technology doesn't always work the way we want it to, but the full lecture is being recorded and we will make it available soon. There should be time for some questions at the end of the lecture, so please make a note of any questions that you may have. For those who are online, please use the chat feature to submit questions, and we'll try and select a few for our guest to see if he can address some of these questions. We have not live streamed any of our lectures before, so this is a new challenge for us. And I request that other than for questions and maybe drawing our attention to any technical issues regarding the live streaming, please do not clutter the chat with remarks or observations, and certainly not any offending remarks or comments, whether about the speaker or anybody else. So I'm pleased to introduce our speaker for the evening, Professor Thomas Hoeren. I have, of course, been told by a reliable source that I have just horribly mispronounced his name, but I have apologized to him in advance. Apparently, I'm just incapable of softening my R's, so a tonal language like Mandarin is a non-starter for me. Professor Hoeren is based at the Institute on Information, Telecommunications and Media Law at the Westphalian University in Münster, Germany. He has been a Superior Court judge and over the last 20 years has been involved in research on intellectual property law and computer law. Professor Hoeren has focused on internet governance and notions of informational justice relating to access to cyber infrastructures. In the past, he did some pioneering work in the field of software law, looking at the nature of software licensing, and in the area of cloud computing. If you think that's impressive, it's all the more impressive when you find out that he actually started in canon law. He has a keen interest in art and is himself an accomplished photographer. However, what I found most interesting about his CV is that he has served as a legal advisor to Borussia Dortmund Football Club, and at various times during this week, he seemed to be making reassuring noises about my prospects of being a target for the club at the next transfer window. I don't know if it's a target or the target, but so the next time you see me, I might be running out on a football pitch with the likes of Torben Hazard, Mats Hummels, and Emre Can. But just remember where you heard the news first. Future annual IP lectures may bring you breaking news in the football transfer market as well. So over to you, Professor Hoeren.
Going on. That's what I was supposed to say. Good evening and guten Abend. I'm proud to stand here and be able to talk to you personally. My topic seems to be rather bizarre. It's only a sentence. Information wants to be free. Who has said this sentence? John Perry Barlow. He was a strange guy. He has composed songs of the Grateful Dead in the 80s, earlier 70s. He was an internet guru, traveling around and telling stories about what should be in the internet. And at a conference in 1996, he said this astonishing sentence, information wants to be free. Information yearns to be free. This simple sentence caused a shock in traditional copyright law. And before you must understand what is traditional copyright law. Traditional IP seems, which is taught even in Germany in most places, has a very, very big peculiar attitude. It's talking about IP. It's mentioned several times, intellectual property. We call it in German geistiges Eigentum. This term is so stupid. If you look to the historical traces of this term, it comes from the Prussian discussion in Germany of 1835 to make the poor politicians understand what is protection of knowledge. The people invented the term intellectual property, geistiges Eigentum. They said, you should protect copyright and creativity because that's stealing. It's stealing like normal stealing, but it's made with immaterial goods. And the stupid politicians said, oh yeah, we understand. We need to protect ourselves even in that specific area of theft. Now they are talking about intellectual property. This intellectual property has a broad scope. The standard of originality is decreasing. As when you see the history of intellectual property, from the starting point, they had high literature, like Balzac or Kotze, all these now very intelligent writers. That's, for instance, copyright. But the level of originality changed during the last decades. It's decreasing. We protect simple design patterns and other stuff. We are protecting more and more under copyright law. And we extend economic rights. A copyright author has moral rights. Nobody is talking about the moral rights. That's a rare topic. But about economic rights, money. When you see the history, the amount of economic rights has increased. A huge variation of economic rights. Copying is forbidden, distribution is forbidden, changes are forbidden. And we have a specific problem in the internet, because the internet, nobody makes a really copy. A hard copy is a rare thing. Nobody is really distributing or selling. So there's a huge discussion going on. How do we apply traditional economic rights to the internet? That especially applies to the question of RAM. RAM is not a Buddhistic sect, it's a random access memory. All these very temporary copies made via streaming. Can we apply principles of normal copyright law to that very strange copies made when you stream? So there's a huge discussion on digital copying, whether it's copy or not, and a discussion on digital distribution, where we can apply the traditional concept of distribution of goods as well to the internet. To tell you the story, fortunately, the European Court of Justice has not decided the matter of digital copying. We are eagerly waiting for a discussion, for a decision on that matter. There's only one very nice sentence in a decision of the European Court of Justice, the famous case Keynote, where the court said, what is that? You cannot believe that this is copying if you're making temporary copies in a random access memory. So I'm really happy for that sentence, but let's wait and see. Another feature of traditional IP law is very strange. We have exemptions. So if you have increased the number of rights and you are protecting more and more of objects, you should of course have exemptions. But in traditional IP law, these exemptions are seen as exceptions. That's very important to understand, because exceptions are interpreted very narrowly. So not broadly, there are exceptions. And exceptions in legal theory are rare rules which you don't apply too broadly. The enforcement is really harsh. That means we have increased the level of sanctions for violating copyright law, not copyright law, patent law. The level has increased during the last decades, so you get severe punishment. And another feature, extension of duration. So the duration of, for instance, copyright law has increased really severely. When you take the Prussian, the first German legislation on copyright law, we had a protection of 10 years after the death of the author. When you see the situation now, we have 70 years, or in South Africa, 50 years, but that's a long time, 50 years after the death of the author. To give you a strange feature, software is protected by copyright law. Who is interested in having 70 years after the death of a programmer, of a nerd, a protection for software? The software is already dead since several decades. So it's a nasty thing to do. But we have even tendencies from the United States, everything which is bad is coming from the United States, of extending the duration. They have made a Mickey Mouse Extension Act in order to have Mickey Mouse protected for a longer period. It was an outcry in the United States because of that, but they made it. And we are obliged, as very obedient Europeans, to do the same thing in Europe. In traditional IP law, they have even extended the scope of neighboring rights. Neighboring rights only protect very minor people as a tradition. But these minor people have asked for the rights to be more and more protected. So the EU, for instance, has invented a database right. So every collection of data is protected under a sui generis right if they are, this database represents a high amount of work and skill and labor. The newest extension of copyright of neighboring rights is press. The press is very powerful in Europe, so they ask every time we need a specific neighboring right for protecting our interests against Google. So they have won the battle, so they have a new neighboring right in Europe for the protection of media against Google. So you see a tendency not only to protect more and more under copyright law, to extend economic rights, to give exemptions as rare exceptions, and to extend the duration and even invent new neighboring rights. But that's not all. What I think is striking under traditional IP law, they think we have nothing to do with traditional civil law. We are a little bit better. We are IP lawyers, not doing nasty things like normal contract law or property law. No, we would never do a lecture on these strange matters. So we are IP lawyers. That has to do, on the one hand, with their arrogance, but on the other hand, with the problem that contract law, normal contract law, includes unfair contract terms and regulations. And there are fearing in the traditional IP laws that these unfair contract term regulation might be applied in copyright law. So they invented a nice term for that. They said, we don't have a normal contract, we don't have sale of rights, we don't have lease of rights in the copyright law, we have a license. If you say the word license in Münster, in my institute, you have to pay 200 rand in a special pocket. Because it's forbidden to say license. In the whole of Europe, you never find any statute which is using the word license. It's coming from the United States again. It's an invention of IBM and Microsoft, because then they can say the unfair contract terms regulation. Oh, that has nothing to do with us. We are only making license, and that's not regulated in normal contract law. So they are out. You see, when you have listened to me, I'm not a fan of this traditional view. Therefore, I'm called our Institute for Information. I will come to that. John Pye Barlow had the same feeling. Something is wrong. And the whole system is wrong when it comes to the internet. And in 1996, he made even a declaration of the independence of cyberspace. He was totally against copyright lawyers, totally against patent lawyers. He said the internet is a free place which cannot be regulated. This declaration was immediately grasped by the colleagues in Harvard, in Stanford, everywhere in the United States. You could have articles on a kind of knowledge commons. So information needs to be free, wants to be free, belongs to nobody. That was a belief in Harvard as well as in Stanford. They even traced the vision back to the old times of Allmende. Allmende was a nice term for commons of sheepherds. They had a common ground for their sheep, which can be used by everybody. The problem with John Pye Barlow, I'm sorry to say that, he was totally wrong, and this vision doesn't work. Why should information be free? Why should there's some information which wants to be paid for? So there's no justification for the stupid sentence, information wants to be free. But what we can learn from John Pye Barlow is this approach, which is our approach at the Institute and in several institutes throughout the world. We say we don't talk about IP law anymore. That's John Pye Barlow. We call it information law. The main topic is the future of information. So then copyright law is only one element in it. The other is a very important element, but there are other elements like data protection, privacy, that are also important in information law. Copyright law is only one element. So copyright law is an exception as such. We need to have the Constitution as framework. In this institute like mine, we start every lecture in the IP law with tracing back the constitutional foundations of IP law. We ask ourselves how and why should an author be protected under the Constitution. So, and if you do that, you find out a balance of rights. because it's not only the author, it's not only the user, it's a triangle. You have the author, you have a person which disguises himself, he is a distributor. The big companies, they're taking away the rights of the author, and you only see the press and the big corporation when they claim that creativity needs to be protected. So, and we have the user. So, our court, German Constitution Court, has made several decisions on this balance. And they say it's a balance where each right needs to be protected to the utmost. So we have to find a balance. And it's not only the author who gets the utmost protection, but the trader as well and the user as well. We need to balance these rights, not only one right. Sorry to say that, but then exemptions are not exceptions. That is what I really strongly believe. Never talk about exceptions when you talk about anything like fair use, fair dealing, and so on. Because if you take the values behind fair use, it's always the constitutional set, it's a protection of the public to get access to certain things. So, an exception is only copyright law. So, but not the exemption. And then you can see with new eyes what is happening in Europe and the United States. It's a hypertrophy of new rights and sanctions. You wake up one day and you say, what are these politicians doing? They are giving more rights to more things which are protected. They reduce the number of exemptions. They have invented new sanctions, new neighbor rights. That's a kind of hypertrophy. It means that the copyright system is exploding. And that's what it's doing in Europe in this moment. You can talk to people on the street about copyright law. We never had that before. 20 years ago, everybody believed copyright law is totally boring. Never talk with us on copyright law. But now you can go to a pub in Borussia Dortmund and say, have you heard about the new directive information society? And people say, yes, I've heard. Very, very big thing. So it's a hypertrophy, an explosion of rights, which is not justified. And coming to that point, unfair contract terms regulation. Of course, copyright contracts are part of unfair contract terms regulation. I would never like to see a situation again which we had when the Federal Supreme Court said we don't have unfair contract terms regulation in copyright law, so you can take away all the rights of creators with one clause in the contract. The court said, sorry, we cannot do anything because we don't have unfair contract terms regulation. No, that's not true. We can apply unfair contract terms regulation. I have done it as a judge 3 times. That was an outcry of hate against me. But it's perfectly okay. And never again. That's, if you don't want to listen to me, there's some dinner waiting outside. You can really be fond of having the dinner and wait and say, well, I don't want to listen to this German guy, he's taking rubbish. But believe in me, there is no such thing as a license. Always ask yourself what is meant with this foggy word, license. And then you can come to the solution. It's a sale of rights. That's exactly what the European Court of Justice has said in the famous Ulstorf case. He said, you can ride on a donkey. It's a horse. It remains a donkey. So that means you can ride on a contract, license. It doesn't matter. It's a sale or lease of rights. And we should, in general, stress the link between IP law and traditional civil law. That's very important. I'm happy to say I'm not only a teacher in IP law, but as well in contract and normal property law. That's good, a combination. So I'm not really afraid. I'm a little bit nervous. I wondered whether I can do it. I'm a stupid German. And I will now talk to you about South African law. That's dangerous. It's only some ideas we came into my mind when I had a flight here. I believe you have the most important and beautiful constitution in the world. It's a very, very good document, and when I've seen these 3 tables outside, I was really impressed, because you have to love your constitution. It was very well drafted. And there you see in Article 16, freedom of expression. Everyone has a right to freedom of expression, which includes the freedom to receive or impart information or ideas. It's a general concept. Everybody, this is a little bit similar to John Perry-Barlow law. Information wants to be free, wants to be used. That's a fundamental right, as well as the freedom of artistic creativity. That's in the same level of protection. And if you take the German constitution, they would say you have to balance these rights and find a solution which is good for both sides. You have a little bit strange concept of property in Article 25. I was not very sure whether property really relates to IP. In Germany, it would relate, it would say intellectual property is property, but only for constitutional purposes. I'm not sure about South Africa. That need to be considered during my next stay. You have a very strong access to information right. Very, very strong. Even against an information that is held by another person and that is required for the exercise of any other right. So there is a strong focus in the Constitution to give access to rights, to information. That relates to other considerations. In South Africa, the Doha Declaration plays a specific role as a declaration important in international industrial property law. It says you have to interpret the regulations of the WIPO according to the purpose of the contract. So broadly, as a freedom to interpret international IP status. And that is similar to Article 39 of your Constitution. I believe the Doha Declaration in international law is only express rules stating the same as Article 39. So you have to find the balance and try to lead every right to its optimum. I've checked all the literature I could get via the internet or in your library. Thank you again for your library access. There was one really remarkable book of Gerardus Verhoeven from 2011. He was a guy who has understood the European way of balancing fundamental rights in copyright law. So he was the first I found who really balanced these rights versus the others. Then, during my stay in Stellenbosch, I found out this remarkable lady, Denise Nicholson. She was fighting for the rights of disabled persons in copyright law and said you need to balance rights like the Europeans are doing. So it's the same approach, and these approaches need to be supported. So that's all. Many things I want to say to Sadullah. This was so charming. The visit was perfect for me. I said to him, this is a visit like Stendhal, who was in the 17th century in Florence. He became sick because he was so amazed. And I feel a little bit like Stendhal. So I was so amazed. I would say the lion sleeps only in the night. So that means, please wake the lion in the day. You have really something to say in South Africa regarding your constitution and copyright law, and I would really love to see people from Nigeria, from other countries, be involved in a process for finding an African way to define IP law. Thank you very much.
Thank you, Professor Smith and Professor Sadullah, as I call him. Our firm has a very long relationship with the university. In fact, it goes back to our birth. So it's the last 15 years, and we really value that relationship. Then, Professor Sadullah, it was so nice seeing your energy again, face to face, in the freedom of being without a mask and to hear your laugh. Professor Hoeren, thanks for your talk. When I looked at the title of the talk, I thought, that's quite interesting, but, information wants to be free, but then the question is, who doesn't? But there's also always the but. But I certainly learned something that I have to be mindful of the term license, and that there is a difference between a horse and a donkey, but the ride can be very similar. And then I just thought to say a few words about free, because we talked a lot about free and what freedom is, and I got onto the internet and explore because everything is free there. Now, I'm not going to bore you with the various quotes I got from famous people on freedom and free, but I realized that freedom is very similar to love, or young love, or love between two people. Just as you think you have it, the goalposts are shifted, either by yourself or by the other party. So I think that's something that one must keep in mind with freedom. And then also comes to mind, I think in the current pandemic, all of us certainly learned a little bit more about what does it mean that your freedom gets taken away. When the Wuhan was shut down, I thought that is only in China where something like that can be done, and I was so wrong. And then I want to conclude, we have another German professor here, Professor Christoph An. He escaped his freedom from Germany. He managed to get to South Africa during lockdown. I believe that he's fully vaccinated because he got in, but he could have used the counterfeit certificate. But during about 2-3 months ago, when we were in level 4, I got worried about my friend, the good Prof, and I phoned him and I said, we can't buy alcohol. How is your wine supply? And was he happy? He said it's become a serious problem and it's not good. And I said, Christoph, I can give you freedom because we have some wine at the office. He says, when can I collect? I said, no, you're an important person. You get other people to do the dirty work, I'll do it for you. So I packaged some wine, suitably disguised, and on it I labeled it Freedom Goods. So when I listened to this talk and I listened to information who has aspirations to be free, all I can say is good luck, because you're going to have lawyers and politicians and social media at the other end. Thank you.
I'd like to thank the Dean for allowing us to host tonight's event. As you know, there are challenges posed by the pandemic. I have to thank Annette and Gretchen who worked tirelessly at the chair to make the necessary arrangements for this evening and to do the marketing of the event via social media and things that are, as they say in Afrikaans, bo my vuur maak plek. I think tonight's live streaming has been a success, Alma. I think it's, despite the early jitters, I think you probably lost about 7 years of your life trying to get us started on time, and thank you for your assistance. And then I want to thank the Dean's Office, particularly Kathy and Gerda. Nothing happens in this building without their assistance. And of course, we are grateful to our generous sponsors, Von Seidels, for sponsoring all the treats and refreshments that we enjoy, and which is supplied by our caterer, Dilly. So we have to thank everyone. But of course, last but not least, thank you for coming once again to support our public lecture. And I urge you to join us for some refreshments in the quad. Thanks.